Good morning, everyone. My name is Kyle Kertz. I'm the managing partner of JonesKertz. Welcome to Startups in the Law. I believe this is I think it's our seventh episode of this. For those of you who are attending for the first time, thank you for coming. For those of you who are returning, if there's anyone that's returning, thank you for coming again. We'll be actually going over some different stuff today than we've gone over before. So it's not going to be a repeat of our first webinar like I did last time, where I went over the basics of just starting a business and what all goes into it, what documents you might see, things like that. So without further ado, we're going to get started. Let's go. There we go. So to give you a little bit of background, the law firm technically has 3 people right now. We just hired a law clerk, but as far as the partners are concerned, Matt Jones is a partner up in Oklahoma. He does a ton of tech deals. He's kind of considered, one of the go-to tech lawyers in Oklahoma. And then as far as I'm concerned, I'm the managing partner of JonesKertz. I handle our stuff down in Texas here. And we do, loads of tech startup deals, loads of contract drafting, loads of other stuff. And here's our contact information. Unfortunately, Matt Jones couldn't make it this time. But if you want to reach out to him, if you're regional to Oklahoma, feel free to go ahead and see if he's available for a chat. You can reach him at mjones@virtuallaw.com. And just to give you guys an idea, we go by 2 separate names in 2 different states. So we're allowed to go by a corporate law firm name in Oklahoma, and we go by Virtual Law Group there. Unfortunately, Texas doesn't allow that quite yet, though we think they might allow that soon. And so for now, we go by JonesKertz. And at some point that may change where, we're both just going by JonesKertz or both just going by Virtual Law. But for now, we have to do that. So by the way, I'm usually pretty open to conversations. I'm usually pretty open to questions. So in the event you have a question here today and you don't really want to ask it, or you didn't get an opportunity to ask it because we weren't really covering that material, feel free to reach out to me at kyle@joneskertz.com. As always, I want to make myself accessible to people and sort of democratize the information that we're giving to people as far as legal knowledge goes, because I think it really helps new entrepreneurs understand what they need to do in order to successfully start a business, as well as lay the foundation to do so. And I think it helps experienced entrepreneurs just, at least cover some of the points that they don't already know, right? So, to give you a little bit of a breakdown on why we do this, number 1, better education. Number 2, better foundation equals more successful startups. To us, that really is the formula. If you are going to start a business, you should probably educate yourself on what you need to know right then. You will be tackling certain problems. You will be addressing certain issues. And you'll realize, I think over time, that some of this stuff just comes naturally. Like you might be mystified right now about what it takes to actually set up payroll or hire an employee. But later on down the road, once you're there, once you need additional support, or you need some other sort of, contract or anything like that, the vision becomes a little bit clearer. You tend to understand, okay, this is when, I should have an accountant step in. This is when I should have, when I should hire an employee or a contractor or something like that. So, this really is our mission with this. We're not selling stuff to you so much as we're trying to provide you with enough information to be able to help guide your decisions. It's sort of like playing bumpers. We don't necessarily want you to take the same exact path as the last person, but we definitely want you sort of following certain protocol when it comes to certain things, right? So, and just as a blanket, a general disclaimer, just keep in mind that anything said during the presentation is not really directly relevant to your situation. While it might seem like it might be, you always want to make sure that you're getting legal counsel if you need it, and making sure that you're not sitting there drafting your own agreements if you're not an attorney. You always want to make sure that you are retaining the proper professionals to do the job that you need to be done. Because I mean, while a lot of people are self-starting, and I know that not law firms, but I know that startups are running very lean. I mean, you want to do what the smart money says, and that's pay people when it's the appropriate time to pay them to do certain work for you and help protect you and your business. So without further ado, we'll get into it. So topics covered today. I mean, I'm just going to go through some legal updates, election updates, as well as, I mean, a topic that I probably haven't addressed in the past, which is exiting contracts the right way. Surprisingly enough, I mean, I don't think this is related to the end of the year so much as it is, I mean, just related to, I mean, we just had a blip where, like a blip in our business where we had a large chunk of clients asking how they could exit contracts. And because we dealt with that over the last few weeks, I thought maybe I should address some of those issues and sort of help you understand, I mean, like what avenues can be taken to actually exit agreements successfully, as well as in a way that will protect your company from further liability, or if you can't protect it from further liability, maybe potentially just additional liability related, or not additional, but the existing liability that you're exiting the contract from with. So as far as election updates go, I mean, first and foremost, it's the last day to vote. Go vote if you haven't done it. I mean, I think if you're in any major city that has a stadium right now, most of the stadiums are probably open for you to go vote. I know in Dallas, the American Airlines Center is open for voting. I mean, I'm assuming that that's the case in Austin, though I'm not entirely sure where exactly, I mean, the epicenter for voting is there. I mean, and there are polling stations all over. It's probably way too late for you to send in a mail-in ballot, though I'm sure they are emptying the bins and counting ballots left and right today. And so, I mean, I would say if your best shot at getting your vote heard, I mean, and not thrown in the trash or burned like we've seen in some of in the news, like is to ensure that your vote gets cast in person. Also, just make sure you're staying safe when you do that. I mean, wear a mask, do what you got to do. As far as what you can expect today, I was actually talking to Trit, the guy who helps moderate this event every single month, and you know, like some of the news is projecting that we're most likely to see results that suggest a clear winner later tonight or early tomorrow morning. Some people are thinking it actually might be later this week because there are going to be lawsuits, I mean, that are attempting to block ballot counts. There are going to be lawsuits that attempt to get recounts. There are going to be lawsuits that attempt to get, I mean, various, I mean, just injunctive relief. I mean, whatever it is, I mean, that you can think of to, I mean, to sort of sway the election one way or the other, or cast doubt on I guess, the efficacy of some of the ballots, or at least the genuineness of those ballots. And I mean, really, like I mean, regardless of what happens here, I mean, no matter what your politics are, I mean, just keep in mind that usually, I mean, the status quo will remain for a certain period of time. It's not like things are going to change overnight. I mean, there's usually a clean transition of power in the event the person who is the incumbent, I mean, which would be Donald Trump today, does not, in which case the incumbent loses. And so, I mean, typically, I mean, at some point there will be a concession from one side to the other. Though I think some people are, it's like if you're into betting, you can probably go online and bet against that, or bet that there won't be a clean transition of power. I mean, it's a very interesting time we're in, very interesting election that's been going on. But as far as we can tell, it's going to be a historic turnout. I mean, to give you an idea, I mean, 80% of all registered voters, at least in Dallas County, are supposed to vote this year, which, I mean, to most people is unheard of, right? I mean, especially this early in the election. And if you think about it, I mean, these are just projections, so the numbers could be far greater than what we expect. I mean, compared to 2016's election. So, I mean, rather important. I mean, pretty serious turnout here. But yeah, like I said, expected onslaught of lawsuits, some of which might be related to the timing of poll closings. Also, I mean, I think I heard a rumor about, I mean, a potential hanging Chad-esque problem. Some people were saying that if the bubbles or whatever was written on the paper mail-in ballot was not properly filled out, I mean, you might have, I mean, what we would compare to a hanging Chad problem, which occurred, I mean, back in not this decade, but the previous decade. So, I mean, in the 2000s, I believe with one of the elections that Bush was elected in. So, I mean, there might be that problem that comes up, which I think might delay the voting counts. So, might be pretty interesting. Anyways, I'm not really going to talk about that very much more. Kind of out of the scope of what we usually do. I don't practice election law, though. I mean, I know lawyers who do, and apparently they make very good money doing it. If you're planning on being a lawyer, it's actually a very niche practice to get yourself involved in, and it's something that is actually, I mean, it's valuable knowledge. I mean, you can't really go anywhere else but to the specialist for that sort of thing. So, anyways, you know, like to give you guys just a primer before we go into the content of this. Over the last few weeks, we've had several people come to us. And I mean, the general conversation was, I mean, what's the proper way of exiting the agreement that I am subject to at the moment, right? So, I mean, one of the most common examples is, I mean, you know, when you're first joining up as a founder with a company, when you're first joining up as an employee or a contractor with a company, you're signing agreements. You're signing an employment agreement. You're signing a stock award agreement. You're signing an independent contractor or consultant agreement. I mean, you're probably also signing one or more things related to confidentiality, intellectual property. You're probably signing something along the lines of a non-compete. I mean, and so at some point you're going to sit there and look at those agreements and you're going to go, I wonder if those are enforceable. Number one, is it enforceable? Is it reasonable for them to hold me to these terms? And number two, I mean, if it is going to be held against me and it is enforceable or it's likely to be enforced, what is a way in which we can sort of wiggle ourselves out of it, or a way in which we can actually engage with the opposite party and exit those agreements? And this is actually, like, normally we're looking at things from a rosy perspective on an ongoing basis. People aren't leaving. I mean, people aren't leaving companies for years at a time. And so, I mean, it's one of those things where, I mean, it's something we definitely need to address. And surprisingly, we've had a lot more business related to this topic. So without further ado, like I said, the common scenario: one business or person enters into a contract with another business or person for products or services. I mean, usually for services, I would say, I mean, our economy, by the way, if you're looking at it as a whole, has actually gravitated, I mean, very similar to Western Europe's economy, where we're much more of a service-based economy. So if you're entering into a contract, more often than not, I will tell you it's probably going to be for services. But and so the deal is struck and contract is signed. Sometime later, one or both of the parties is at odds, or maybe they're not even at odds. It's just somebody had another opportunity pop up and they just need to exit, or something came up. They just need to do something else, or, I mean, they have to notice that they're not going to perform, right? And I mean, in situations that you're exiting amicably, I mean, these are very practical things. There's some very practical things that we can do to ensure that, number one, I mean, you don't have any ongoing obligations. And number two, you're both parting ways. It's very mutual. I mean, there's not going to be much of a dispute that arises out of it. I mean, other things considered, right? So, I mean, and in some cases when it's not amicable, but it is maybe in a way more hostile, or at least you're just in your own corners, I mean, one or both of the parties may want to avoid litigation and be released from one or more contractual obligations and avoid litigation. And so, I mean, to serve those purposes, the question becomes, what agreement or document do we use? And the answer, it depends on the type of agreement you are exiting, or the type of agreement you are transitioning out of. Because sometimes it's not just a full-blown exit or termination. we're more transitioning or delegating performance, which we're going to talk about that here in a minute. And I am going through some of this stuff pretty quickly. I do have other content, by the way, at the end of this that I might cover. But I do want you guys to jump in with any questions that you have. And so, I mean, I'm going to go into the first agreement right now, but please feel free to stop me because, I mean, I'm sure some of y'all might have questions about this. So it is like something that is probably not as common for deal lawyers to enter into or at least draft for clients is what's known as a termination agreement. I mean, typically, if you look at contract terms where, I mean, you've engaged with another party to render services or have engaged with another party to purchase their services for a certain amount of money or stock, for instance, if you're hiring on somebody who's in essence going to be a co-founder of yours. I mean, you're probably going to have pretty one-sided termination language, which will say something along the lines of the company upon 7 days notice can terminate this agreement with cause or without cause. I mean, for any reason or no reason at all. Sometimes those termination clauses come with terms that say with or without notice. It's usually not very standard that you have termination without notice because, I mean, for the most part, in order to terminate an agreement, I mean, you have to make the other party apprised of the termination. And so whenever I see something that says that you may terminate this with or without notice, I'm like, well, that doesn't make any sense, really, if you think about it. I mean, so yeah, but as far as termination agreements go, by definition, a termination agreement is mutual if it's an agreement, right? So, I mean, really, you call them mutual termination agreements, but it's the same thing. I mean, these might apply to many different types of agreements, right? So, I mean, it's not necessarily boxing ourselves into any one agreement. These things have optionality language, and by that I mean we can actually sit there and just change the terms to say whatever the title of the document is that we're canceling. We usually attach the document that we're canceling or terminating as an exhibit. And then there's some things that do go into the negotiation or some things that must go into the agreement so that we're preserving certain rights. So let's say, for instance, we were terminating a restricted stock purchase agreement mutually between a service provider to a company and the company itself. Well, I mean, if we're going to do that, I mean, obviously we probably want some of the clauses that are supposed to survive that agreement, I mean, to survive, right? So we might have the non-compete terms survive. We might have the non-solicitation terms survive. Any repurchase option if it's not being exercised at that time. I mean, as well as any other rights that might make sense to include as a surviving term. I mean, the other thing you might ask for is indemnification. You might ask for, I mean, if you don't have a non-compete in one of the agreements, if it's a negotiated deal point, you could ask for it. I mean, termination agreements, by the way, I mean, as far as covenants go, I mean, covenants are promises to do something or continue to do something in the future. I mean, you could covenant for non-disparagement. I mean, I believe that's fairly common, though. I mean, you have to watch that because sometimes those things last forever. Usually, I mean, we want those people to be far enough away from us, like as far as time goes, to where, I mean, if you were to even talk ill of that person, it wouldn't even matter at that point. Though I'll tell you, from what I can tell, a lot of non-disparagement clauses don't even have durations on them. They're just blanket non-disparagement agreements. So one of the major points I wanted to talk about here is, in the event one or both parties are claiming the other party breached, you can enter into what is known as a release. So you might have heard of a settlement agreement and release of claims, or a settlement and release of claims. I mean, same concept, a termination and release of claims. I mean, if you're mutually terminating agreement, if one party or both parties have alleged that the other side has breached a part of the contract, that they have been damaged, or that they might have a cause of action legally, what you can do is one side can pay the other, or, I mean, if you're both sitting there going, okay, let's just break up at the moment. I mean, you can put it, you both can just mutually agree to terminate. And actually, I did look up the law on this before I got on the presentation to double check. So as far as consideration goes, and keep in mind, like, one of the elements of a valid contract is you must have consideration. So something paid for in exchange for, as far as the bargain goes, right? So, I mean, you're bargaining for services. I'm paying you in the form of stock or money, right? Or a mix there, or a mix of both, really. In some cases, confidential information can be considered consideration that would make a contract valid. But in some cases, with a termination agreement, well, we call them agreements, and they are indeed contracts. A lot of times, the law will actually look at a termination agreement and say, you know, I mean, true consideration in the form of money, in the form of stock, or some other intangible form of I mean, some other form of payment that could be recognized under the law. I mean, the law usually says, you know, we don't really need that in order to terminate an agreement. You guys should be allowed to decide that on your own without needing anything more. But if it ever were an issue and you were saying, okay, I don't want to give that person thousands of dollars and I don't want to give them hundreds or even 100, you could say something along the lines of, I guess, I mean, for $10 and other good valuable consideration. We sometimes see that on real estate agreements that may or may not work. If you ever thought that that might be in dispute, but I mean, as far as this goes, you usually don't need money to terminate an agreement unless the other party is asking for it and you're willing to give it, right? So I think I'm going to move on to other forms of agreements. Yeah, by the way, as far as release agreements go, I'll talk about this generally. When you're entering into a settlement and release or a termination and release, the release itself is important. So I reviewed a release agreement the other day. I mean, it was really a settlement release, but it never released, it never truly released one of the parties from any liability. So this person technically agreed to pay a very large sum of money, I might add. I mean, we're talking well in excess of $250,000. Like without getting any sort of warranty from the person receiving that money that they would not pursue litigation against them. I mean, which I mean, to be honest with you, like, this is lawyer day one stuff. I mean, you need to get that release. I mean, it's a condition, I mean, to the deal. I mean, you're really not agreeing to those agreements unless you get a release from them making a claim against you. And so I found it quite odd that that was the case. I don't think that will be the case of going forward for that client now that they are a client of ours. But I thought that was very interesting. Trey, do we have any questions so far? Yeah. Okay. So moving on. This is one of the questions that we actually had earlier this week. So exiting a non-compete or non-solicitation agreement waiver and release. You know, I think practically everyone who is involved in the startup world, if you have started a business, you have probably entered into one of these agreements, or if you have co-founded a business, or if you have done anything related to starting a business, whether it be providing services to a business or not, or anything directly related to the work that the business was doing, you probably, I mean, were bound by one or more agreements that had a non-compete or non-solicitation. So in the state of Texas, to give you an idea, a non-compete and a non-solicitation provision are treated both as a non-compete. Because they both function really to, I mean, stifle competition and prevent you from doing things that would otherwise be considered competitive behavior or activities. So, I mean, and the difference is a non-compete is usually we're saying, I mean, you're not allowed to compete with us as far as going after, current customers that were known to you at the time, as well as prospective customers that were known to you at the time. I read the law on this the other day. It's kind of wishy-washy, but typically former customers are usually not in play with those agreements, even if that term is in there, mainly because, well, if the customer left you or left the company that you have a non-compete with, well, then, I mean, we're going to say, well, they broke up with you anyway, so that person is usually just fair game. And so, like, I mean, a non-compete can also be, I mean, you're not going to compete as far as, attempting to seek employment at a similar place for a certain period of time. That might be one. Usually there's a balancing act that goes along with these. I mean, usually we're balancing what is the geographic restriction, what's the scope of that restriction, and then on the other side, how long does this last for? What are the other terms? Is this thing reasonable, and is it drafted just so that it protects the company and its trade secrets and whatever other valuable assets and confidential information it might have? So obviously, and then on the flip side, a non-solicitation agreement, usually it's the company telling you and you promising not to go solicit customers, go solicit employees, go solicit contractors. I mean, usually the stuff about employees can be enforceable depending on how it's written. Stuff about contractors, the law really isn't that clear on that. I tried to find a case on it the other day, and I really couldn't find one that spoke to that directly. But as far as the customer thing goes, I mean, current and prospective customers that were known to you, that you took out to lunch, yeah, that might be binding on you so long as the other portions of the non-solicitation are, drafted reasonably. The same terms apply pretty much. What's the duration, geographic scope? Does it prevent you from really doing your job or anything like that, or using your skill set? Yeah. So, as far as this goes for exiting a non-compete, so the idea would be, let's say you were leaving a company, and you really are going to do exactly the same job function. You're a contractor for them, or you're an employee for the current company, but you're going to leave to start your own company. And actually, the pool of service providers, the pool of customers, very narrow pool. You really can't go to very many people to get the same services, to do the same work. So you really are going to have to tap into that same exact pool of people, that same exact pool of customers. To the point where inevitably you would be in violation of a non-compete or non-solicitation clause that you'd signed. So, in that case, we can enter into like a waiver and release of non-compete or non-solicitation obligations. These are contracts that exist, and we draft for people sometimes to exit those situations, and usually we're paying people to do that, right? So instead of the employer paying you, for a change, you're going to pay the employer. Whatever amount gets negotiated, whatever amount gets agreed upon, there really is no amount that is common, that is too common when it comes to this sort of thing. And I would say lower the better, obviously. We definitely want to make sure you're never paying too much money for it. If we represent the company, we're going to be like, hell yeah, give us $20,000, or whatever's reasonable. In reality, I'll tell you, like, most people are not going to go like, give me $100,000 to not compete with me, unless of course you're about to make millions, in which case you would actually be able to do that. To be honest with you, that would be extremely uncommon, by the way, if it ever happened. It usually doesn't, unless you're somebody who, probably works as, what would it be? A good example would be like a head coach for an NCAA team. You're going to have a pretty hefty non-compete agreement when it comes to those. And there will be break fees. There will be, stop clauses in there that are designed, to basically stop paying you any amount of money you would be owed under the contract. If you were to go compete. And so the difference is here, you can have a mutual or unilateral waiver, meaning, we can both agree, the employer and the former employee, to release you from the non-compete. And the release and waiver can be a one-time, or it can be a permanent, or it can be just for a certain period of time and then it reactivates. I mean, there's really no one way in which we do that, but like I would say more common. I mean, we're gonna try to go after a permanent waiver, because if we're getting involved, if we're doing that, I mean, we probably want to just go for it all and say, let's get you out of this thing for sure. I mean, that said, if we can't do that, a reasonable ask is to ask that person to release you. I mean, just once. I mean, and say, you know what? I mean, we'll allow you to go get a few of these customers. We will not consider those. I mean, those customers that you've acquired that I mean, you would have cultivated here at our business. I mean, to be in competition or to be a breach through this agreement, and you can specify that in those agreements. So there's a lot of different ways you can cut this. I mean, but I would say, I mean, the more often than not, I mean, we're going to be going after a mutual permanent waiver and release from all of that in exchange for a sum of money, or in exchange for you potentially maybe giving your shares back or something like that, which would be a form of payment. Aside from that, I mean, yeah, we talked about, I mean, the consideration. I mean, just keep in mind that, I mean, your mentality when you are entering into a non-compete agreement should not be that you will be exiting it in this way. It should be that you will exit it naturally, meaning you will exit it upon the expiration date set forth in the agreement, which is usually worded to say, I mean, it's the duration or the term of the agreement plus 2 to 3 years. And to give you an idea, 2 to 3 years is really common. Sometimes we get people negotiate down to 1. I recently negotiated a non-compete that lasts for 18 months. I mean, that's fine. I mean, if you're talking 18 months versus 2 years, who cares? Really, I mean, it's almost the same, to be honest with you, unless that person's definitely leaving to go compete. But usually, I mean, they're not going to compete directly with your company unless you don't have really any moat at all to do that. I mean, aside from that, though, I mean, you're like, I would say 4 and 5 year non-competes are very uncommon unless we're binding you. I mean, in a way in which you're benefiting as like a C-level executive. I mean, so, I mean, if you're going to be a CFO of a company that's worth 10 million or more, or if you're going to be a CFO of a company that's or a CEO of a company that is already making profit at the moment, they very well may bind you to a 5-year non-compete. But I'll tell you, the provisions there will be more heavily negotiated if they're giving a 5-year non-compete, because 5 years is a lot of time, and it's pretty much the max limit that most states will even allow. I mean, I've done extensive research on this in the past, and I mean, there are some people who have attempted to do 10-year non-competes, and I think most states in the nation have pretty much said that's not going to fly, only because we aren't. I mean, that would be considered 1/4 of a person's working life. Probably more than that, actually. It'd probably be, for some people, 1/3 of their working life. And so, I mean, that's a long, long time. And so 5 years in that context is a long time as well. Jeez. But anyways, as far as I mean, these go, you can definitely use this as an option and use it as something to bring up in the event you need it. And actually, I mean, the other day I brought this up to a client, and it appears he's moving in the direction of asking for one of these and just having a conversation about it with his former employer. And I mean, the worst that person can really say if you go ask for one is no. And so, yeah. So, do we have any questions about the previous stuff? I mean, I sort of talked about a lot of non-compete law there, and actually, that's common misconception, by the way. One of the things I pointed out, like I posted this on LinkedIn the other day. A lot of people think that non-competes are actually like not enforceable. It's not true. Not in Texas. I mean, the non-competes can be enforceable in Texas. They generally are not. I mean, some non-competes may be considered unenforceable, but Texas allows for what is known as blue penciling, which means that in the event that the non-compete agreement is written in a way that's not necessarily enforceable or not reasonable, but close enough to where if they just modified it slightly, it would be reasonable, the court will just go ahead and do that and basically just amend the agreement for the parties. So that said, I don't really like, as far as practicing law goes, I don't really like that, because I mean, if it's not going to be enforceable, I mean, I would rather it not be enforceable, because in my opinion, we draft contracts. We need those agreements to be enforceable. We need to have done our job when we did those. So just a matter of opinion on that subject. So, I mean, another thing is a separation and release of claims agreement. So if you're exiting an agreement and there truly is a bona fide dispute on the subject, I mean, you're likely to have quit already or terminated an agreement, and one party, especially in the employment context, is likely to have, I mean, effectively. Gosh, my computer is going off right now. Whatever, we'll see if that stops. As far as I mean, as far as exiting those agreements, or at least resolving the issues in a way in which we do not have to go to court, a separation and release of claims agreement is very common. Sometimes these are, these are heavily negotiated, especially if people want non-disparagement agreements, especially if they want reiterations on non-competes, especially if they want certain clauses to survive. I mean, in this case, I mean, the employer, I mean, may think they can be the big bad wolf and sort of do a little bit of puffing and bolstering and say, you know what, you can just go ahead and take us to court. I mean, we have more capital than you. But at the same time, almost nobody likes to go to court unless they're reasonably likely to win, or just have, or just of the mentality that they must defend any case really in court. And so I'll say a lot of people, they're willing to sign one of these so long as it's reasonable, so long as the money's there. And I mean, in some cases, we will just, like, if somebody's alleging something, just to get past it, we will propose something like this to ensure that there are no further issues. And I'll tell you, that comes in really handy, especially when startups are raising money. Take, for example, the situation where, a company has an employee or a shareholder dispute. That thing is pretty hotly contested to the point where the parties have actually gone and sued each other. The parties, are counterclaiming against each other. They're actually digging in a little bit. But the problem is the company itself, from a financial perspective, its bank account is doing this on a monthly basis. And so they're sitting there going, we need capital to keep running. We need money to keep going and to keep paying our service providers. And so they may just say, to hell with it. We just need to settle this so that, we can all move on. And in the event that litigation has already been actually in process, they'll enter into one of these agreements and then notify the court that they have done that. And one of the parties will dismiss with prejudice, subject to the other conditions of the agreement. So, and typically when a party does that, usually that contract, that settlement agreement, is a new agreement. It's a new debt obligation. Sometimes it even comes with a promissory note where, if you default, you're going to have an interest payment, that sort of thing. And it does help you sort of walk away. And I would say money is almost always changing hands in these situations. We are definitely paying people off. Or I should say not paying people off, but paying people a settlement so that, the company can relieve itself of a litigation issue or something that is standing in the way of the growth of the company. And so, in the context of startups, you cannot really go and raise money like when you have litigation ongoing. Part of the disclosure process, part of the due diligence process for venture capital firms and private investors is going to be to run a background check on your company as well as the founders to ensure that they have clean hands, to ensure that there's no pending litigation against them, because investors see that as a potential risk for investment. So, the clear example would be, mean, you've got 100,000 in litigation, but you're raising $250,000. Okay, you receive that $250,000, and then the investor just wants to know that that goes straight into the company and nowhere else. I mean, but to pay for the company's growth or to pay for whatever, I mean, the purpose of that transaction was. I mean, they do not want to see or even really get a hint that you might pull that money out and use it to pay off your other creditors. So, or at least use it to settle something like that. So usually a good thing to settle that. I mean, in any event, you do take investment when you do have litigation ongoing or have a dispute ongoing. Best practice, disclose it. I mean, what's the worst that can happen? I mean, this person will say, I don't think it's the right time. You fix that problem, we'll give you the money. So as far as problems that can be solved, I mean, this is a useful tool when it comes up. It's not always employment related. I mean, sometimes this can be, injury related. If you had somebody who, just got injured on a site, where you were, or, it could be property related where, property was damaged. You somehow you got into some industrial incident, or basically committed a tort against someone else or somebody else's property. And so you might just go ahead and solve those issues with a settlement agreement of release of claims. So another point at the bottom of this, though, very easy for companies to run afoul of employment law. It happens pretty often. It does. It's a minefield out there. And if you're planning on doing anything that's employment law related, you certainly, if some things are straightforward enough, yes, you could do them conceptually on your own. But I would say if you're hiring people and you're not an attorney, even if you are and you're just not used to hiring people, maybe consult with an attorney or at least do some research on your own before you decide to take the plunge. Because it comes up often that we get people who are suggesting to us what they want to do, but we end up having to tell them, hey, you can't do that. Examples, most common example, especially in this context, might be, people who have withheld payment because a service provider did not provide them a service, or a service provider actually did provide them a service, but they considered it unsatisfactory, despite the fact that that wasn't the term of the deal. I would recommend that, unless you can easily prove that the service itself never materialized in any way, then withholding payment, might cause you more problems than not. And at that point, it's not a matter of, hey, I can coach you how to do this as a layperson. It's, if that's the situation you're in, talk to an attorney about how to approach it, or at least get the attorney to run offense or defense on your behalf, right? So, do we have any questions about that? I'm sort of addressing a broader topic here, and so while not all of this is about just contract clauses, all of it is related to exiting circumstances in contracts and agreements, things like that. So yeah, if we don't have anything else, we'll go forward. So I wanted to talk about this. I actually love this concept. This is really nerdy, but the novation agreements are not a thing apparently in every state. As far as contract law goes, Texas is one of a few states that allows for what is known as a novation agreement to be entered into. So there's actually a very famous case that sort of tells us that, you could have solved this problem with a novation, and it's actually called the condom sense case. In Dallas, if you're from DFW or you live in Dallas, you may have seen a business called Condom Sense. Condom Sense, apparently, when it opened up, this was the subject of an appeals court case or a Supreme Court case. I can't remember off the top of my head, but I know that it was precedent at that time. The Condom Sense, before it was legitimately and originally formed as an LLC or a corporation, the proprietor of it, entered into a commercial lease agreement. And apparently the commercial lease agreement itself, At some point he decided that he was going to breach it, or at some point just did as a matter of course. And so he had done that, like he had entered into the agreement under under the LLC name that had yet to be formed actually. And so, the law told us that technically that did not, constitute legal protection. He didn't get the zone of protection around him that an LLC would have provided in that context, and because it hadn't yet been formed. And so technically, the value of the contract was imputed to the individual, the proprietor. And so, and so this is a very important lesson. Number one, if you're going to enter into a name, or if you're going to enter into a contract under a certain entity name, it better damn well be the entity name, and it better not be anything else. Because if it's not, because if it's an LLC and you put Inc. at the end of it, well, that's wrong, and potentially you could be personally liable for that sort of thing. The solution to that agreement, though, is what we're talking about right here, the novation agreement. So a novation operates similar to an assignment, but with one major difference. A novation is a new agreement which discharges one party of an obligation to perform under a contract while simultaneously transferring that obligation for performance to another party. So in essence, it substitutes the one party for another, and it's not treated the same way as an assignment is in the state of Texas. So in the state of Texas, if you assign an agreement with no other terms, it's just a bare assignment basically, then effectively you may have created a situation in which you or the entity you are operating as the assignor, the person who has assigned the agreement to the assignee, are still liable for it. So, there are cases in which, people did not understand that assignment didn't mean they could just wipe their hands clean. It actually meant that they would still be liable for it if the assignee did not actually fulfill the obligations under the agreement. Now, usually when you're assigning an agreement, you're obtaining approval for it, right? So it's a form of exit for a contract, but if you're assigning an agreement rather than obtaining a novation for that agreement or a novation for certain obligations, then in essence, you really do need to actually have other protection in place. You need to have indemnity. You need to have, basically balancing. Balancing of, you need to be able to step in that person's shoes and defend a case if necessary. And also, you may want to have, an open line of communication with the. You may want to have an open line of communication with the other party, because if you've assigned something to that other party, you definitely want to make sure that if they send you an email representing to you, basically telling you, yes, I've done what we were supposed to do. Yes, the company has completed its obligations under this agreement. You really want that to be the case. And really the best way to do that, another way to exit an agreement is to get a notice of termination or a notice of release, or a notice of fulfillment of an obligation from the party that has been fulfilled, basically. So, that's a way in which you can protect yourself in the assignment, context. The novation agreement, though, these are pretty short. They can be longer, but they're usually about one page. I looked at one and it was literally like 2 paragraphs and a signature block. It's nothing. But you have to make sure, though, when you're entering into a novation, a novation cannot be entered into unilaterally. You could not just draft one yourself, sign it, and then send it to the other party. That's not enforceable. It really needs to be signed by both parties to an agreement, where, actually we're talking 3 parties in which, you're talking about the transferring party, you're talking about the receiving party for the obligation, and then you're talking about the party to which services, or the obligation is supposed to be rendered, basically. And so, it's a pretty interesting subsect of the law. But going back to that case, there are potential uses for it. So let's say that in the condom sense case, where this guy who was basically running a sex shop, entered into an agreement with a commercial landlord to rent a place out for his shop, but did so in a way where in actuality, the effect of that was that he was personally liable for it because the entity did not exist at the time. I mean, because he didn't have an LLC set up yet. I mean, he could have executed a novation agreement if the landlord had allowed it, that would have let him basically say, you know what, I'm no longer going to be personally liable for this going forward. I mean, the company is. And I think what I just said is actually one of the more important things to understand about this. So it really is a forward-looking instrument, not a backward-looking instrument. So it does not absolve the person transferring the obligation for what they've done in the past. So if you've done anything that could be considered willful misconduct, a breach of the agreement, something that caused damages, something that, I mean, you're going to be liable for or might be liable for, the liability still exists so long as the statute of limitations hasn't run out, so long as, I mean, other factors willing. I mean, sometimes with statute of limitations, there's a discovery element that's required. I mean, it's upon when one of the parties who has been who is suffered as a result of whatever contract violation has discovered that you have violated, at which point the clock starts to run. I mean, these are forward-looking agreements. Keep that in mind. I mean, you do not get to just wipe your hands clean of everything you've ever done in the past if you sign a novation. It's not the way that works. So pretty interesting stuff. I mean, they can also be used for other stuff like delivery of goods or performance of services. I mean, but I would say if you're gonna think about this practically, I would say the best use of this, well, maybe not the best use, but an appropriate use would be transferring liability from one entity to another for the remainder of a lease agreement, or transferring liability from yourself to a new entity that you have. And these are agreements that can be executed for other things too. So, I mean, let's say you've contracted personally for development services for an app that you're developing, right? I mean, well, you could potentially go get an agreement with, or you could potentially execute innovation with the software developer, so that you're no longer personally paying this. The entity that you've set up, that you've capitalized, that has money now, I mean, is now going to start paying him or her, I should say. So as far as this goes, I mean, this presents, I mean, a unique option that I don't think a lot of people realize is available to them, especially for startups. I mean, startups all the time are entering into agreements where, I mean, the agreement is with the founders personally for one reason or another. I mean, it happens all the time. And so, I mean, as you grow, as you start your business, as you actually get everything set up and fully formed, you may consider, I mean, trying to persuade a few of, your service providers or the people you work with to sign one of these things, so that you can, properly structure, I guess, your liabilities or, your obligations under contract. So one of my favorite things to talk about. Anyways, do we have any other questions? I mean, I sort of went through that in depth, and I know there was a lot of legalese, but anyways, yeah. So, I mean, here's an example. So company agreements. If you have an LLC and you have a company agreement in the state of Texas, which if you're not in Texas right now and you're listening, a company agreement is the exact same thing as an operating agreement, literally everywhere else but Texas. We just call it something different because we have to be special. The example here is, I mean, let's say you enter into a multi-member agreement. The truth is, you're sort of treating it like you would any sort of startup, right? I mean, you don't want to be there forever, but you need to be there for a certain period of time in order for your equity to really take hold and vest. And I mean, you really do want the mechanics of how you leave to be more transparent, to be more, cut and dry, black and white. You'll structure the company agreement in such a way that it will actually determine, okay, here's how the fair market value is being calculated, which is not always written into there. I mean, you'll see a lot of times that we have appraisal language for fair market value, like we have to have a third-party independent appraiser do the fair market value appraisal. I mean, there's dispute resolution sometimes that go into those. The reality though is you can make this more of a contract term where you're saying we're just going to do a discounted cash flow analysis, put a multiple of 3 or 5 on it, and call it a day or something like that. That said, whether you actually want to do that, I don't know. I mean, DCFs tend to work better, I think, for profitable companies, but that's for more financially knowledgeable people to figure out, or at least tell us that they want. And so, if you're going to do those more structured terms, though, for calculating such a thing, you really ought to pretty much be able to know that the company is going to be profitable, because we have to know that the company will have the capital in the event of exit, right? Or at least we have to make the capital amounts condition upon whether or not the company is capitalized. So, but yeah, we can, in many cases, actually attach a promissory note to a company agreement, which I think provides a certain level of security. As a matter of fact, it can be a secured instrument to where, you can secure it against the collateral, against certain collateral of a person, and become a lien holder in some cases. But oftentimes, I think we're not securing it so much. Other than, it's just a promise and a debt obligation of the company that, if you default on payments of the promissory note as the company paying the promissory note to the person who has exited the company, you're going to be liable for it. So they could attack the company's assets for that. As far as seeing these in these agreements, it's not that common, but I did have a lawyer the other day actually negotiate one of these into a membership interest purchase agreement for somebody that we helped exit a company. We had an unfortunate situation where, a few founders had to tell the other founder they didn't want to work with him anymore, and they worked out a deal. And while we had a purchase agreement set up for it, and all the language was really in there, the opposing counsel in that situation attached a promissory note, which was secured. Which I was like, okay, whatever. Yeah, I think it's one more agreement. It potentially makes it a little bit stronger, but if it's not being personally guaranteed by one or more parties, or if the company simply doesn't have the assets, it does very little extra good, in my opinion. But I'll tell you, if you're exiting and you're notifying that you're exiting, or you're conditioning payment like that on being terminated for cause or something like that, then yeah, you can, or if you can condition it on really anything you want. But I would say more often than not, promissory notes are common if, you're being terminated for cause, being terminated without cause, and then potentially in situations where there's a change of control. You may, if the change of control isn't for the disposition of the entire company, they may be able to ask that they get bought out, basically. It's not that common, like I said, but sometimes it's viewed as a good way of structuring the exit from a profitable business. It also just, in some cases, you may make potential shareholders, or, well, not shareholders in the case of LLCs, but potential members or managers who are receiving membership interest as a result of their work, a little bit happier and a little more satisfied knowing that they will have a way to get paid on the out. So, if we don't have any questions about that, I'll go ahead and move to the next slide. Yeah, so for corporations, very similar to what I just discussed, would be a buy-sell agreement. You're basically, stipulating restrictions on transfer in a buy-sell agreement, as well as, setting certain triggers, for I guess termination of that person's ownership and how they are to be paid out. Termination can be by death. It can be by leaving employment. Termination for whatever reason or for cause. It can also be, to the point where, in some cases, these things say, the money being paid will be paid to the estate of the person who's died. And I mean, in some cases we do see, I mean, like this is what the valuation of the company, or the company must provide a valuation on an annual basis to all shareholders, which, I mean, effectively, it might be expensive if you're paying a third party to do that for you. But at the same time, some shareholders want to be kept relatively in the know as to what their shares are worth, and because that makes it easier for them to time the exit. And so, I mean, they'll receive that for 3 or 5 years, and at some point along the line, I mean, decide, okay, now's the time to exit. I mean, the stock is falling, not rising anymore, that sort of thing. Yeah, like I said, transfer restrictions, terms on which transfer can be made, notice provisions for the transfer as well, obviously essential in those agreements. Helps you exit those, I mean, relationships, I mean, your ownership in a company. Similar to LLC operating agreements, company agreement language. I mean, though I would say slightly different. I would say if you're looking at, I mean, comparing apples to oranges, what we prepare for people, I mean, a stockholders agreement, in my opinion, is it is far more similar to an operating agreement for an LLC than a buy-sell agreement is to an operating agreement for an LLC, though some of the terms clearly overlap. Aside from that, so yeah, we've got properly written assignment provisions. Gosh, I mean, it's common that some of these provisions are really not worded properly. It's not like, I would say it's not hard to draft these, but I mean, sometimes you see one that, I mean, you're sort of looking at it and it raises an eyebrow and you're like, I don't know if that was actually drafted by a lawyer, or if it was, I'm not sure if they had been up all night drafting that. Because I mean, sometimes these things are worded in a way in which, I mean, it should clearly benefit them, or it should clearly benefit the drafting party, but doesn't for whatever reason, or just is inappropriate for the contract. And so, I mean, in reality, if you're looking to exit a certain relationship at some point, or looking to structure your business in a way to make it more flexible, more dynamic, in case somebody comes in, swoops in and says, I want to buy 100% of you. I want to buy all the stock. I don't want to buy 50% of it. I don't want to buy 25% of it. I want everything. I mean, true change of control, true acquisition. I mean, in that case, you might want to have a really good assignment and delegation provision in each of your agreements, so long as you can manage that. And keep in mind, like, you really do, like I tell people, don't negotiate everything. But if you are eyeing an acquisition in the near future, you may take an inventory of which clauses, like in your contracts, that you have outstanding with service providers, with people that you work with, I mean, with vendors, which ones that you can effectively assign. I mean, to give you an example, commercial real estate agreements are fairly difficult to assign. And there are ways around this, and I'll touch on that here in a minute. This is a more complex legal concept, but I mean, it's not something that I think I need to go too in depth. But I mean, as far as assignment goes, assignment provisions are your friend. I mean, you really do want the language of these things to be such that you can maneuver, I mean, from, I mean, controlling the entity to being bought out without this activating any sort of right by the other party to the agreement. So you don't want to really be in the situation where, I mean, you need to assign this agreement. The other party is not going to allow you because of the way the clause is written, and it is enforceable. And so, I mean, they're basically saying, you know what? I mean, because an acquisition is about to happen, I'm just going to terminate this agreement. And sometimes that does happen. I mean, they will attempt to, I mean, they won't block your acquisition, but what they're effectively doing is using it as a negotiation tool to make more money off of you. Because if a company does know that you're being acquired, they could use an assignment provision that's favorable to them to get more money out of your company, or get more money, I mean, from the person who's acquiring. Which, I mean, obviously we want to avoid as much as possible, because we want you to make more money. We don't want to drive up the cost or the liabilities. I mean, when it comes to you being acquired by a company, right? So these are a useful tool for exiting situations, or at least continuing them. I mean, as far as as far as exiting situations go, I mean, it's more a matter of allowing the company itself to assign the agreement and relieve itself of control, really, or the obligation itself. So I mean, but as far as this goes, I mean, assignment provisions, I mean, sometimes they are what they are. You can't really get anybody to agree to allow you uh, to give you a favorable assignment provision or give you a mutual assignment provision. It's also not as common that the agreement says either party may assign, I mean, this agreement with or without notice to the other party. I mean, usually we're those clauses are pretty one-sided, so that we know who has that right and who doesn't. So yeah, I mean, as far as this goes, though, if you're looking at the example here, I mean, this is more, I would say, it's more of an M&A type of example for this. I drafted this really quickly. I mean, the reality is, I mean, keep in mind, like, I mean, when it comes to assignment, there are certain ways around it if you can't get around it. I mean, one of the more common ways in which you could potentially get around it would be through what's known as a reverse triangular merger. That is a more of a complex legal concept, and something that, I mean, if you have to do it, potentially going to drive up your legal fees substantially, because we have to basically start 1 to 2 more entities just to facilitate the RTM. I mean, there's resolutions that go into it. I mean, there's a very defined process, and there's case law to support, I mean, at least in Delaware, that sort of thing, absent, I mean, some provision stating otherwise, or mentioning such an assignment through that sort of mechanism directly, that it could be I mean, you could be able to wiggle out of it to a certain extent. I mean, yeah, but I would say don't go around trying to do RTMs or reverse triangular mergers on your own. It's not something that I would recommend anyone but a lawyer do. And I mean, I would probably say that most lawyers aren't capable of doing it. So, but yeah, I mean, as far as assigning, as far as delegating goes, the other option would be, I mean, just obtain consent to assignment. I mean, there's agreements for that. And I mean, all of this is, I mean, get creative with your vendors, get creative with your service providers, get creative with the people that you work with. And I mean, couch it in a way where they believe, I mean, what you believe, which is this is advantageous for both of us. And I mean, that's the way you want to do this. And so, I mean, you don't have to sit here and say, well, I mean, throw your hands up in the air. There's nothing that can be done. Well, I mean, have you even asked? Well, I mean, I guess one of the other questions is, should you even ask? Is it going to alert that person to something that you're not allowed to do? Is it going to alert that person to something that they're going to try to, I mean, exert pressure on you, ask for more money, what have you? So as far as this goes, I mean, I would say, like, as far as exiting agreements goes, just to recap, I mean, you definitely want to be keeping, I mean, some of this in game in mind as you enter into agreements. I know some people who are, I mean, they're just dying to do business to the point where they're just looking to get an agreement that will serve its purpose now. But whenever you're entering into contracts, I mean, the lesson that I mean, what I usually tell people is, imagine that, I mean, that person is never going to agree to let you amend that agreement. Would you like for that to be enforceable 5 years from now? If not, let's probably go through and draft something that is more appropriate for you. If that requires that we slow things down a little more, so be it. I'll tell you, a lot of times when we do slow things down, we actually discover that we end up with better terms, or we discover that, I mean, the more thought that the founders or the people running the business did about the issue, I mean, the more we changed it to where it actually benefited them more. And I mean, we more strategically thought things through, more strategically negotiated things. I mean, and just more strategically planned for the future with those agreements. And I mean, with that said, I mean, as far as contracts go, I mean, keep in mind, it's all about a plan. I mean, at some point you want your stuff to be so good that you could potentially, I mean, just give a data dump of documents, and that person who's receiving them, if they're looking at acquiring you, would be like, this is good. I mean, they protected themselves. I mean, not a whole lot of issues there. I mean, something that they can easily see value in. And so, and that's really the ultimate goal with all these contracts. I mean, we're not just getting you into agreements, we're getting you to the other side where the grass may be greener and the cash might be too. So with that said, if there are no other questions, if you have any other if there are no other questions for all of this stuff that we've talked about, I mean, I'll go ahead and say goodbye. If you have any other questions though, feel free to contact me at kyle@joneskertz.com. Or feel free to hit our website and fill out our contact form at joneskertz.com. Thanks. Appreciate it. Bye, guys.